We'll begin the program shortly. Good evening all. I request everyone to take your seat, and I request the dignitaries to kindly come over to the stage. I request the dignitaries It gives me immense pleasure to welcome all the dignitaries who are present here, and I request the dignitaries to kindly come over to the stage. Kindly come over to the stage. Debates are often one of the best ways in which a piece of information can be analyzed in depth. We all have heard it is better to debate a question without settling it than to settle a question without debating it. Good evening all. Constitutional Debate Club is a registered organization under the aegis of the Kerala High Court Advocates Association. The club has been organizing debates, speeches, colloquiums on various relevant constitutional topics with active participation from senior counsels, lawyers, former judges of the High Court, and also the sitting judges. This time, the club decided to have an academic discussion on a very relevant topic, powers of the governor under the Constitution of India, which will enlighten all of us about this constitutional post, its power and functions. Today, we have gathered here for a colloquium on powers of the governor under the Constitution of India, conjointly conducted by Kerala High Court Advocates Association and Constitution Debate Club. To begin with, I request everyone to rise for a silent prayer. Thank you all. I take this opportunity to welcome Dr. Tushara James, Secretary CDC, to deliver the welcome address.
Distinguished dignitaries on and off the dais, ladies and gentlemen, dear friends. My limited role today is to welcome the esteemed guests and this august audience to this colloquium jointly organized by the Kerala High Court Advocates Association and the Constitution Debate Club. The advocates of Kerala, individually and collectively, have always had an impressive repute as intellectually strong and academically inquisitive. The Constitution Debate Club was conceived as a platform for free and creative exchange of ideas and ideals, primarily relating to the Constitution. Working closely with our Advocates Association, the club over the years have been successfully conducting debates and discussions on topics of legal relevance and social importance. The choice of the topic for today's colloquium was finalized by the Constitution Debate Club, giving it, of course, a very serious thought and considering the role and relevance of the governor, who is the first citizen of the state to which he is appointed as the governor, vis-a-vis his role, responsibilities, powers and limitations as a constitutionally defined authority. For an understanding of the subject, today we couldn't find a better choice of speakers and moderator. For the speakers, we have three eminent personalities before you. Advocate V.D. Satishan, a postgraduate in social work, completed his LLB from the Kerala Law Academy and LLM from the Government Law College, Trivandrum. He was also one among us as a practicing lawyer till he joined active politics. He was first elected to the Legislative Assembly in 2001 and he repeated his victory in 2006, 2011, 2016 and 2021. Advocate V.D. Satishan is presently the leader of opposition in the 15th Kerala Legislative Assembly. On behalf of the Advocates Association and the Constitution Debate Club, and on behalf of each one of us present here, I welcome you, sir, to this colloquium. Dr. Thomas Isaac, a name that rings a bell in many of us, is primarily an economist with a sharp legal acumen and political strategy. He was a professor at the Center for Development Studies, Trivandrum, before he committed himself to the political machinery of the state and country. His PhD thesis, titled Class Struggle and Industrial Structure, a study of coir weaving industry in Kerala, 1859-1980, is in itself an academic masterpiece. He is a former MLA, member of the Kerala State Planning Board, and the Minister for Finance and Coir. But probably he is most known for his tenure as the Finance Minister of the state of Kerala, when the entire taxation system was taking a paradigm shift from state laws to the comprehensive unified GST regime. I welcome you, sir, on behalf of the Kerala High Court Advocates Association and the Constitution Debate Club, and on behalf of each one of us present here today. Advocate B.G. Harindranath, former district judge, former law secretary, and a former faculty of the National Judicial Academy at Bhopal. He spearheaded and smoothened the legislative machinery of this state as it passed through a very crucial phase of lawmaking. His remarkable innings as the Law Secretary stands testimony to his deep knowledge and voracious reading. The most important legislations of the state proudly bears his sign and seal. On behalf of the Advocates Association, the Constitution Debate Club and all of us, I cordially welcome you, sir, to this colloquium. With the list of 3 spectacular speakers rolled out, here comes probably the best piece of cake in the form of our moderator. Professor Dr. G. Mohan Gopal is a face of the legal fraternity in the state, in the country, and at the global level. A former director of the Judicial Academy of the Supreme Court of India from 2006 to 2011, the founder chair of the National Court Management Systems Committee of the Supreme Court of India from 2012 to 2019, former director vice chair of National Law University at Bangalore and of Bhopal, Dr. Professor G. Mohan Gopal is a name that has no parallel in the academic and judicial world of this country. His views have more often than not tempered, toned, and tuned the legal and judicial fabric of this place. And for the same reason of tempering, fine-tuning, controlling, managing, opining, and giving serious thought to the most important subjects that the state deems fit, we cordially invite you, sir, as the moderator of this program. On behalf of the Advocate Association, the Constitution Debate Club, and all of us, I extend to you, sir, a cordial welcome. Advocate Rajesh Vijayan is the familiar face of the Kerala High Court Advocates Association. The president of the association has always been giving immense support and coordination for all activities of the Constitution Debate Club. His interest in nurturing the academic growth of the legal fraternity is what has positively contributed to the growth and development of the Constitution Debate Club as well. I welcome Advocate Rajesh Vijayan to this program. We acknowledge the presence of Learned Advocate General, Learned Additional Advocate General of the state, Learned Senior Advocates, Learned Advocates, Learned Law Officers of the center and the state, other dignitaries who are present here, officers who have come from statutory corporations, standing councils, students who have come from various institutions, the media personalities, and the public who have shown genuine interest in the academic discussions conducted by the Constitution Debate Club. Once again, I welcome each and every one of you, the members, the distinguished dignitaries, and the audience to this colloquium. Welcome you all.
Thank you, ma'am. I request Advocate Rajesh Vijayan, President, Kerala High Court Advocates Association, to deliver the presidential address.
Good evening. ബഹുമാനപ്പെട്ട പ്രതിപക്ഷ നേതാവ് ശ്രീ വി ഡി സതീശൻ, ശ്രീ തോമസ് ഐസക്, ശ്രീ അഡ്വക്കേറ്റ് ഹരീന്ദ്രനാഥ്, ഈ കൊളോക്യത്തിൻ്റെ മോഡറേറ്റർ ഡോക്ടർ മോഹൻ ഗോപാൽ സാർ, സീനിയർ അഭിഭാഷകരെ, അഭിഭാഷക സുഹൃത്തുക്കളെ, കോൺസ്റ്റിറ്റ്യൂഷണൽ ഡിബേറ്റ് ക്ലബ്ബ് നിരവധി വർഷങ്ങളായി ഹൈക്കോർട്ട് അഡ്വക്കേറ്റ് അസോസിയേഷനോട് ചേർന്ന് നിരവധി ഡിബേറ്റുകൾ, അതും ലൈവായിട്ടുള്ള സബ്ജക്റ്റുകൾ, ഇന്നും വളരെ ലൈവായിട്ട് നിൽക്കുന്നൊരു സബ്ജക്റ്റിലാണ് നമ്മുടെ കൊളോക്കിയം മുമ്പോട്ട് പോകുന്നത്. എന്തുകൊണ്ട് കേരള ഹൈക്കോടതിയുടെ ഉള്ളിൽ ഉള്ള 3 ഹോള് വേണ്ട എന്ന് വെച്ച് ഈ ഹോളിൽ നടത്തി എന്നൊരു ചോദ്യം ഇവിടെ വന്ന പല അഭിഭാഷകർ എന്നോട് ചോദിച്ചു. അതിനൊരു കാരണം, ചില ഭാഗങ്ങളിൽ നിന്ന് ഇൻസ്റ്റിറ്റ്യൂഷണൽ കേർട്ടസി ഈ വിഷയത്തിൽ വേണം എന്നൊരഭിപ്രായം ഉയർന്നു വന്നുകൊണ്ടാണ് ഈ വിഷയം ലൈവായിട്ട് നിൽക്കുന്നതും കേരള ഹൈക്കോടതിയിൽ ചില മാറ്റേഴ്സ് പെൻഡിങ് ആയതുകൊണ്ടും നമ്മൾ കേരള ഹൈക്കോടതിയുടെ പ്രമൈസസിനുള്ളിൽ വെച്ച് വേണ്ട എന്നുള്ളൊരു തീരുമാനം എടുക്കുകയായിരുന്നു. ഞാൻ സ്പീക്കേഴ്സിൻ്റെ സമയം ഒട്ടും തന്നെ എടുക്കാൻ ഉദ്ദേശിക്കുന്നില്ല. പ്ലീസ് എൻജോയ് ദ ഡിബേറ്റ്. താങ്ക് യു.
Thank you, sir. Let me now invite Advocate Preeta CG, Executive Committee Member, CDC, to give an introduction to the colloquium.
Dignitaries on and off the dais, lawyer friends, brothers and sisters who are present here. Namaste and a very good evening to all. The colloquium of the day is organized by the Constitution Debate Club in association with the Kerala High Court Advocates Association. The Constitution Debate Club is a registered organization formed with an intent to deliberate and discuss on relevant constitutional matters, thereby enlightening and updating the fraternity of the day-to-day legal issues. The club was formed in the year 2018. Since its formation, the debate club has arranged debates on several topics. A few among being need for restriction on media reporting regarding judicial matters, requirement of fixing an upper time limit for approval of colloquium recommendation regarding appointment of judges, and also propriety of reflection of personal opinion of judges in the judgments. We have also conducted talks and colloquiums on relevant subjects. After a short break on account of the COVID pandemic, the activities of the club were resumed in August 2022 with a much participated debate on the topic constitutionality of marital rape. Honorable judges, senior advocates, and the lawyers at large wholeheartedly participated in our event. Today, we are heading for a discussion on a very live and relevant constitutional subject, that is, powers of the governor under the Constitution of India. Unlike previous occasions, this time we are enriched by the presence of eminent political leaders and leading academicians in the panel. We realize the gain is certainly ours, and the floor is now open for the esteemed speakers. We are looking forward to receiving holistic knowledge on the subject, since we are blessed with speakers who will deal with not only the provisions but also with the ideal manner in which this constitutional office is expected to function. We thank the eminent panelists for accepting our request. Thank you.
Thank you, ma'am. I take this opportunity to invite Dr. G. Mohan Gopal, former Director, National Judicial Academy, Bhopal, and former Vice Chancellor, National Law School of India, University, Bangalore. He's a vibrant academician, and we are indeed fortunate to have you here, sir, as our moderator for the session. We welcome you, sir, once again.
Respected Advocate General of Kerala, other very distinguished advocates, members of the legal fraternity, other distinguished members of the audience who are here from various walks of life, students, and on the dais, a very respected panel here, Dr. Thomas Isaac, Mr. V.D. Satishan, Mr. B.G. Harindranath, all very eminent and respected leaders of our society. It's a great honor and a privilege for me to be here in all your midst and to share some thoughts on what is really a very burning topic. And what we've discussed and we propose to do is for each of us to speak initially for about 15 or 20 minutes, and then to invite questions from the audience and react to those questions. Because of the structure of the audience, what we would suggest is that those who have questions may write the questions down briefly on a piece of paper and hand it to one of the organizers, and they will hand it to us. We'll pass it around and respond to the questions. I know that we are all here, including those of us who are on this side of the dais. We're all here to try to understand what is a very complex issue, very baffling issue. We have here with us many senior lawyers who know very well, and many others who know very well, the very detailed provisions of the Constitution, extensive provisions of the Constitution on the powers of the governor under the Constitution of India. The powers are wide-ranging and are greater than the comparable powers of the President of India. So, for example, there is no obligation written into the Constitution. There is a convention, but there is no obligation written into the Constitution that the governor shall act on the advice of the Council of Ministers, which the President is bound to do. The governor has wider roles than the President does. There is a possibility under the Constitution, which we have seen happen, of the governor actually ruling, exercising the executive power as the head of the executive when President's rule is declared. Such an eventuality does not and cannot exist under the Constitution in the center. There can be no President without a Council of Ministers. But here there can be a governor without a Council of Ministers under the Constitution. I would say if we single out for the most significant provisions in the Constitution which are unique about the powers of the governor, I would single out 4 powers which are extraordinary. One is the virtually unbridled discretion in the Constitution itself. There are many conventions binding this discretion, but constitutionally unbridled discretion to choose the Chief Minister. Not just in Kerala, I'm talking structurally, all over. Now, when there is a clear majority, then there is very little room for mischief or controversy. But when contests are close and a decision has to be made who should be invited to form a government, there is very little constitutional structure or guidance to this very crucial discretion vested in the power of the governor. When there is the ability, again, through convention, the power of the governor to ask for the government to face a no confidence motion. Politically, very, very powerful and very significant decision has been read into the powers of the governor, not written explicitly in the Constitution. And so the ability to decide which elected person will rule the state is not only vested in the governor, but there is very little guidance in the Constitution. Much of it is governed through convention. The second very powerful area, which is unguided, I'm focusing on the sort of dangerous areas of the powers of the governor, is the power to give assent to bills or to legislation enacted by an elected legislature, to sit on the approval for any period of time, and then to return it for reconsideration without the corresponding clarity in the case of the president, where if it is returned, the president has to approve it. No such clarity is there in the case of the governor. And also the power to reserve bill for president's assent. Again, there is no clear guidance in the Constitution in this respect. Imposing president's rule, by contributing to imposing president's rule by giving a report under Article 356 is another huge power, reporting that there is a breakdown of the constitutional machinery in the state. All of this creates in the governor, in addition to the governor's power to raise issues and controversies, make accusations, create issues, enormous power to destabilize an elected government through speech and action, and actually to build up an opposition and lend power to those who are against the government, a role that was clearly not envisaged in the Constitution. So I would say these are four very, very vital areas where the governor has no explicit power under the Constitution, but nor does the Constitution bridle or restrain those powers. So we have to ask ourselves, and that's the main point I want to make, why did the Constitution create a possibility for a governor? The Constituent Assembly considered the possibility of an elected governor and rejected it, saying that we don't want two elected people competing with each other, the chief minister and the governor. That was rejected. And yet, and there are at least 30 or 40 other powers which I'm not reading out or referring to here because all of you know it and there's no time. But the question is, why did the Constitution get structured this way? With such a massive amount of power vested in an unelected appointee of the President of India. So the conventional explanation is that it was a way to keep India united. After the partition, there was a fear that there will be more secession from India. So the governor's presence was presence and powers are very important, more than even that of the president, to keep India united. That is certainly one important reason why the governor is given vast powers, even more than the president. But there is, in my view, another power, another very important reason. And that reason is that there was a strong view amongst progressive people in Parliament, Dr. Ambedkar, Jawaharlal Nehru and others, that regressive social forces will dominate local and state level politics and bodies. So like it happened in the United States, they wanted a progressive union to drive progressive social change and liberal ideas against fierce resistance of local established oligarchies at the local level. And therefore Ambedkar himself was not in favor of strong federalism. He favored greater power for the union. In fact, until before partition happened, the residual power was actually vested in the states and not in the union. And the big structural change took place reacting to partition. But Ambedkar always saw the village, the rural areas, the hinterland as a place of oppression, social oppression, and social oligarchy, and to be fought and destroyed by using the powers of the union. And so the governor was seen as an instrument of progressive change to confront the regressive forces at the local and state level. And therefore the so many powers were vested in the governor. Why? Because the Constitution is seen. The Supreme Court has said this many, many times, starting with Keshwananda Bharati, picking on the writings of Mark Galanter and his books on the Constitution of India. They accepted his views, and on the judicial side, they have described the Constitution as a charter for social revolution, not social change, not social reform, but social revolution, to destroy a social order, an oligarchic social order, dominated by a small elite, and bring about a new social order. So we have Article 38 that says that the state shall promote the welfare of the people by securing as effectively as it may a social order, not a political order or economic order, but a social order in which justice, social, economic and political, shall inform all institutions of national life. That was the mission of the entire republic. The purpose of the republic created by we the people was actually to construct a new democratic social order based on the 4 core values of equality, liberty, dignity, and fraternity based on these 3 values. A new social order. So, if you look at the Constitution as an instrument of social revolution, driving social revolution against a society that was very, very conservative and regressive, then the instrumentalities of the state, of the union, became the most available and most convenient tools to be used to drive that social change. Unfortunately, no one expected that in the 8th decade of the Constitution, this would be reversed. Not in all states, but in a significant part of India, especially in the south of India, the states have become the progressive forces. And what is more dangerous, the union has been captured by the enemies of the republic. Those whose ideology, written ideology, commits them to overthrow this constitution in order to establish what they call a Hindu Rashtra. If you read Golwalkar, he clearly says that the purpose is to establish a Hindu Rashtra. Our constitution is not a Hindu Rashtra. His followers are in power. They have sworn an oath to the constitution, but their real aim is to implement the vision of Golwalkar and other ideologues who want to establish a theocratic state in India, which they cannot do without overthrowing the constitution. So for the first time, in a serious and substantial way, the constitution is now under the control of its enemies. And what we are witnessing is actually a coup. We are witnessing in our front of our eyes a coup. The constitution is being overthrown, bit by bit, little by little, being dismantled and replaced. Now, what is the heart of this alternate vision of a Hindu Rashtra? There are 3 elements to it. One is its unitary nature. Unitary nature. Golwalkar says you should have one nation, one unitary nation. You should not have states. You should have areas, administrative areas, A, B, C, D, E, F. This is another vision. I'm not here to criticize it. I'm just putting the facts before you. This is what he says. You should have administrative regions that cut across religious, linguistic and other identities, because you can then destroy these identities and then construct one identity based on their concept, his concept of what is a Hindu. Borrowed also from Savarkar, those whose homeland is India and those whose holy land is India. So committed to the values of the old old Vedic civilization. So this idea of creating a unified, unitary state based on one uniform, homogeneous identity is at the heart of this idea of the Hindu Rashtra, and that is completely opposed to the constitutional vision of plurality and diversity and liberty and equality, and Article 29, which says every segment of the people who have a distinct language, script and culture have the right, fundamental right to conserve the same. Minority rights under Article 25, protecting diversity, protecting the last idea of the least person from being attacked by a majoritarian set of ideologies. So these two ideas are clashing with each other. And what I would like to submit is we should focus not on the irritants that are being used, the tools that are being used by the governors in terms of their attacks and the issues they raise, but to understand that what they are doing is that they are actually building a unitarian state. By destroying local forces, destroying local political forces, and ensuring that governors effectively become governors with a small g of all the states which have not accepted the ideology of the Hindu Rashtra. So they are encouraging these forces, they're destabilizing forces that are committed to the ideals of the Constitution, and they're weakening them. They're using one excuse or the other to weaken them. So you will find this going on wherever there are progressive states. You may not find it in non-ruling party ruled states where the ruling dispensation is not so progressive. But wherever there are regimes which are committed to democratic ideals, you will find that there is a concerted attempt to divide and to weaken and destroy these forces. So we must understand that we are in the midst of an attack on the Constitution. The governor was certainly not intended to be an instrument of attack on the Parliament, but we need to expose this truth to the people. We can't simply say he's attacking a party, he's attacking a chief minister, he's attacking institutions, vice chancellors, education, or in other states, other such symptoms. Yes, that's true, that's important, that's wrong. But what is going on is much deeper than that. It is to attack competing ideologies and ensure that the project of converting India into a unified Hindu Rashtra is taken forward, to reinforce the social, primarily caste oligarchy that still rules India. So once we are able to communicate this to the people, they will understand that the role of the governor has become an enemy of the Constitution, the enemy of the Republic. Not the governor, but the role of the governor has become a great danger to the Republic and a great danger to the Constitution. That should then lead us to asking, what do we do about it? And I think the next step is for us to ask that the position of governor should be abolished and build public opinion for that. We don't need the position of governor anymore. We don't need the position of governor anymore. There may have been a need at a time when there was a risk of secession and India was not stable, but in the 8th decade, people ask, how long will you continue reservation? Because they don't understand what reservation is in a different context. It's a constitutional feature. My question is, how long will we continue a governor when we have stabilized as a democracy? And so we can, like the union government, can never function without a prime minister. Can never function without a prime minister. There cannot be a situation where there is no prime minister. Similar situation will apply to a state also. A state, if you say that you must have a chief minister, without a chief minister, the state cannot function, then a chief minister will come. So we must ask for the abolition of the post of the governor on the basis that the post of the governor is being used to destroy the fundamental, basic structure of the Constitution of secularism, democracy, socialism, and all these ideals. As an alternative, we must revive the demand that was made in the Constituent Assembly and abandoned at that time in a very different environment. Until we have the position of governor abolished, and we can discuss what the practicalities of that is, but it's whatever practicalities are created by the abolition of the post of governor will not be dangerous to the Constitution. It will protect the Constitution. But if that is, until that is realized, we must at least demand that we must have an elected governor. An elected governor. We must revive this idea of the Constituent Assembly that the governor must be elected. And then once a governor is elected, frankly, an elected governor and an elected government will be much less mutually destructive, institutionally destructive, than an unelected governor whose mission is to destroy the Constitution, overthrow the Constitution, and I'm not talking of a particular governor, I'm talking of the office, whose office is being used to overthrow the Constitution. So therefore, I think we must think radically. Simply reacting to individual governors in Tamil Nadu or Kerala or West Bengal, who's become strangely quiet. He's not treating the Prime Minister the way he used to treat the Chief Minister when he was Governor of West Bengal. And now, obviously, I was looking forward to his questioning the Prime Minister as Vice President of India, the way he was questioning the Chief Minister of West Bengal. But hopefully he will start doing that soon. But we are not talking of particular governors and their particular actions. But structurally, the time has come. We are mature enough as a democracy. The political class needs to have confidence in itself. The political class has no confidence in itself to say, we don't need a governor. We don't need some patron to control us. So we must ask for that. And if not, we must ask for a governor to be elected. We must also make people aware of the underlying nature of the challenge that we are facing, what the real design is behind the working of the governors, of the office of the governor in different states, that part of an ideological assault on the Constitution to overthrow the Constitution and establish a unitary Hindu Rashtra. So this is what I want to submit in my 15 or 20 minutes. I will be happy to answer questions or interact in the interaction. May I request Mr. V.D. Satishan to share his thoughts with us.
ശബ്ദം വളരെ കുറവാണ് എനിക്ക്. ഞാൻ വളരെ കുറച്ചേ പറയുന്നുള്ളൂ. സൗണ്ട് റെസ്റ്റ് ചെയ്യണമെന്ന് ഡോക്ടർ പറഞ്ഞിരിക്കുക. എന്നാലും ഈ ചടങ്ങിൽ പങ്കെടുക്കാൻ കഴിഞ്ഞതിൽ അതിയായ സന്തോഷമുണ്ട്. അഡ്വക്കേറ്റ് അസോസിയേഷനെയും അതുപോലെ കോൺസ്റ്റിറ്റ്യൂഷൻ ഡിബേറ്റ് ക്ലബിനെയും ഞാൻ പ്രത്യേകമായി അഭിനന്ദിക്കുകയാണ്. പ്രിയപ്പെട്ട മോഡറേറ്റർ ഡോക്ടർ ജി മോഹൻ ഗോപാൽ, ഡോക്ടർ തോമസ് ഐസക്, ശ്രീ ബി ജി ഹരീന്ദ്രനാഥ്, അധ്യക്ഷൻ ശ്രീ രാജേഷ് വിജയൻ, മറ്റ് സഹോദരങ്ങളെ, സുഹൃത്തുക്കളെ, വളരെ പ്രധാനപ്പെട്ട ഒരു വിഷയമാണ്. ഗവർണറുടെ അധികാരങ്ങളെക്കുറിച്ചാണ്, ഭരണഘടന നൽകുന്ന അധികാരങ്ങളെക്കുറിച്ചാണ് നമ്മൾ ചർച്ച ചെയ്യുന്നത്. ഇന്ന് രാജ്യത്തിൻ്റെ വിവിധ ഭാഗങ്ങളിൽ നിന്ന് ഗവർണറും ഗവൺമെൻറ്റുകളും തമ്മിലുള്ള കോൺഫ്രണ്ടേഷനെക്കുറിച്ചുള്ള റിപ്പോർട്ടുകൾ വിവിധ സംസ്ഥാനങ്ങളിൽ നിന്നും വന്നുകൊണ്ടിരിക്കുകയാണ്. ഒരുപാട് പരാതികളാണ്. തിരഞ്ഞെടുക്കപ്പെട്ട ഗവൺമെൻറ്റുകളെ ഒരു ന്യൂയിസൻസ് ഉണ്ടാക്കിക്കൊണ്ട്, കോൺസ്റ്റിറ്റ്യൂഷൻ ഒരു ഓർഡർ തെറ്റിച്ചുകൊണ്ട് ഒരുപാട് പ്രശ്നങ്ങൾ വിവിധ സംസ്ഥാനങ്ങളിൽ ഉണ്ടാകും. അപ്പോൾ എന്താണ് നമ്മുടെ ഭരണഘടന ഗവർണർമാർക്ക് നൽകുന്ന അധികാരം, എന്താണ്, എന്ത് പവേഴ്സാണ് അവർക്കുള്ളത് എന്നതാണ് നമ്മുടെ ചർച്ച. യഥാർത്ഥത്തിൽ ജൂൺ 1, 1949 ഈ വിഷയം കോൺസ്റ്റിറ്റ്യൂവൻ്റ് അസംബ്ലിയിൽ ചർച്ചയ്ക്ക് വന്നത്, ഗവർണറെ സംബന്ധിച്ച ചർച്ച ചെയ്യാൻ വന്നത്. അന്ന് ഡിസ്കസ് ചെയ്തത് on June 1st, 1949, the powers that a state governor must have was a contentious issue in the Constituent Assembly debates. Everyone agreed that governors would act as representatives of the national government, much like the governors chosen during the British Raj. ഇതൊരു പ്രധാനപ്പെട്ട കാര്യം. ഇതിന് മുൻപൊരു ആക്ട് ഉണ്ടായിരുന്നു, ബ്രിട്ടീഷുകാരായി, 1935 ആക്ട്. ആ ആക്ടിലെ ഗവർണറെക്കുറിച്ചുണ്ടായിരുന്ന പ്രൊവിഷൻ അതുപോലെ തന്നെയാണ് കോൺസ്റ്റിറ്റ്യൂഷനിലേക്ക് അടർത്തിയെടുത്തത്, അതുപോലെ തന്നെ. പക്ഷെ 1935 ആക്ടിലെ വ്യത്യാസം എന്ന് പറയുന്നത് ധാരാളം പ്രോവിൻസസ് ഉണ്ടായിരുന്നു. ആ പ്രോവിൻസസ് ഒക്കെ ഉണ്ടായിരുന്ന സമയത്ത് ആ അന്നത്തെ സിസ്റ്റം, കോൺസ്റ്റിറ്റ്യൂഷണൽ സിസ്റ്റം, ഇന്നത്തെ സ്റ്റേറ്റും യൂണിയനും എന്നുള്ള സിസ്റ്റം അല്ലാത്ത ഉണ്ടായിരുന്നൊരു സിസ്റ്റത്തിൻ്റെ കാലത്ത് 1935 ആക്ടിൽ ഗവർണർക്ക് കൊടുത്തിരുന്ന പവേഴ്സ് അത് തന്നെയാണ് നമ്മൾ റിപ്പീറ്റ് ചെയ്ത് ഈ നമ്മുടെ കോൺസ്റ്റിറ്റ്യൂവൻ്റ് അസംബ്ലിയിൽ വന്നത്. ഇത് കോൺസ്റ്റിറ്റ്യൂവൻ്റ് അസംബ്ലിയിലെ ഡിസ്കഷൻസ് നോക്കിക്കഴിഞ്ഞാൽ നമുക്ക് വളരെ കൃത്യമായിട്ട് നമുക്ക് മനസ്സിലാവും. ആർട്ടിക്കിൾ 163 ആണല്ലോ ഇതിനെക്കുറിച്ച് പറയുന്നത്. It says the governor must act as per advice of the Council of Ministers, but except in so far as he is by or under this constitution required to exercise his functions or any of them in his discretion. അത് 1935 ആക്ട് അതുപോലെ തന്നെ ആണ് റിപ്പീറ്റ് ചെയ്തിരിക്കുന്നത്. ഈ ഡിസ്ക്രിഷണറി പ്രൊവിഷൻ എന്ന് പറയുന്നത് 1935 ആക്ടിൽ നിന്ന് അതുപോലെ തന്നെ നമ്മുടെ കോൺസ്റ്റിറ്റ്യൂഷനിലേക്ക് എടുത്ത് വെച്ചിരുന്നതാണ്. ഒരുപാട് പേര് ഇതിനെ ക്രിട്ടിസൈസ് ചെയ്തു. ഈ ഒരു പ്രൊവിഷൻ നീക്കം ചെയ്യണമെന്ന്. എച്ച് വി കാമത്ത് ഒരു അമെൻമെൻറ്റ് മൂവ് ചെയ്തു. ആ അമെൻമെൻറ്റ് വളരെ ക്ലിയറാണ്. ദാറ്റ് ഇൻ ക്ലോസ് 1 ഓഫ് ആർട്ടിക്കിൾ 143 അത് അന്നത്തെ ഇതിലാണ്. ദ വേർഡ്സ് except in so far as he is by or under this constitution required to exercise his functions or any of them in his discretion be deleted. അതായത് അമെൻമെൻറ്റ് മൂവ് ചെയ്ത് ആ അമെൻമെൻറ്റിനെ കുറിച്ച് വലിയ ഡിസ്കഷൻ നടന്നു. പക്ഷെ അമെൻമെൻറ്റ് പാസ്സായില്ല. അത് മെമ്പേഴ്സിൻ്റെ കൺസേണിനെ കുറിച്ച് അംബേദ്കർ കൺക്ലൂഡ് ചെയ്തു. അദ്ദേഹം പറഞ്ഞത്, ദ ഫസ്റ്റ് തിങ് ഐ വുഡ് ലൈക്ക് ദ ഹൗസ് ടു ബെയർ ഇൻ മൈൻഡ് ഈസ് ദിസ്: the governor under the constitution has no functions which he can discharge by himself. No functions at all. Even under this article, the governor is bound to accept the advice of the ministry. Ambedkar further elaborated that while governors will have no functions, they will surely have duties to perform. The two duties of the governors that Ambedkar described are: one is that he has to retain the ministry in office. Because the ministry is to hold office during his pleasure, he has to see whether and when he should exercise his pleasure against the ministry. The second duty which the governor has and must have is to advise the ministry, to warn the ministry, to suggest to the ministry an alternative, and to ask for reconsideration. Therefore, having regard to these two duties which the governor has, namely to see that the administration is kept pure, without corruption, impartial, and that the proposals enunciated by the ministry are not contrary to the wishes of the people, and therefore to advise them, warn them, and ask them to reconsider, I ask the House, how is the governor in a position to carry out his duties unless he has before him certain information? In the debate regarding the appointment of the governor, Ambedkar made it amply clear that governor has no power of interference in the internal administration of a ministry which has a majority, and thus there is no need to spend profusely on an election to choose the governor. ഈ ഗവർണറെ എലക്ട് ചെയ്യണോ വേണ്ടേ എന്നുള്ളതൊരു ക്വസ്റ്റ്യൻ ആയിരുന്നു. മോഹൻ സാറ് പറഞ്ഞു, എലക്ട് ചെയ്യണോ വേണ്ടേ എന്നുള്ളത് കോൺസ്റ്റിറ്റ്യൂവൻ്റ് അസംബ്ലിയിൽ വലിയ ഡിസ്കഷനായി. എലക്ട് ചെയ്യപ്പെടണോ ഗവർണറാണ്. അപ്പോൾ അംബേദ്കർ അതിന് തന്നെ മറുപടി പറയുന്നുണ്ട്. ദി ആസ്പെക്ട് ഓഫ് ദ ക്വസ്റ്റ്യൻ വിച്ച് ഈസ് മെറ്റീരിയൽ ഈസ് ദ ഗവർണർ ഗോയിങ് ടു ഹാവ് എനി പവർ ഓഫ് ഇൻ്റർഫിയറൻസ് ഇൻ ദ വർക്കിംഗ് ഓഫ് എ മിനിസ്ട്രി വിച്ച് ഈസ് കമ്പോസ്ഡ് ഓഫ് എ majority in the local legislature. If that governor has no power of interference in the internal administration of a ministry which has a majority, then it seems to me that the question whether he is nominated or elected is a wholly immaterial one. If the constitution remains in principle the same as we intend that it should be, that the governor should be a purely constitutional governor with no power of interference in the administration of the province, then it seemed to me quite immaterial whether he is nominated or elected. അപ്പോൾ പവർ ടു ഇൻ്റർഫിയർ അതില്ലാത്തത് കൊണ്ട് എലക്റ്റഡ് ആണോ നോമിനേറ്റഡ് ആണോ എന്നത് ഇമ്മെറ്റീരിയൽ ആണ് എന്നുള്ള കൺക്ലൂഷനിലാണ് അദ്ദേഹം എത്തിയത്. ശരിക്കും പറഞ്ഞാൽ എച്ച് വി കാമത്ത് വീണ്ടും ഒരു ക്വസ്റ്റ്യൻ റൈസ് ചെയ്യാൻ വേണ്ടി എഴുന്നേറ്റു. പക്ഷെ അപ്പോൾ ചെയർമാൻ അംബേദ്കർ അല്ല, ഡ്രാഫ്റ്റിംഗ് കമ്മിറ്റിയിലല്ല, അസംബ്ലിയിലെ രാജേന്ദ്ര പ്രസാദ് പറഞ്ഞു ഇത് ക്ലോസ് ചെയ്തെന്നോ, ഈ ഡിസ്കഷൻ ക്ലോസ് ചെയ്തു, കൺക്ലൂഷനിലെത്തി എന്നാണ് അദ്ദേഹം പറഞ്ഞത്. ഒരുപക്ഷെ കുറച്ചുകൂടി ഡീറ്റെയിൽ ആയിട്ടുള്ള ഡിസ്കഷൻ കോൺസ്റ്റിറ്റ്യൂവൻ്റ് അസംബ്ലിയിൽ നടക്കുമായിരുന്നുവെങ്കിൽ ഈ 1935 ആക്ടിൽ നിന്ന് അതുപോലെ പകർത്തി വെച്ച ഈ ഡിസ്ക്രിഷണറി പ്രൊവിഷൻ മാറ്റാമായിരുന്നു. പക്ഷെ പിന്നീട് പല പ്രാവശ്യം കോടതികളിൽ ഇത് വന്നപ്പോൾ, ഈ ഡിസ്കഷൻ വന്നപ്പോൾ, ഈ ഷംഷേർ സിംഗ് വേഴ്സസ് സ്റ്റേറ്റ് ഓഫ് പഞ്ചാബ് 1974, ദാറ്റ് വാസ് ദ ഫസ്റ്റ് കേസ് where a 7-judge bench of the Supreme Court had examined the powers and functions of a state governor. The court held that the governor does not enjoy any executive powers and that he can act only on the aid and advice of the Council of Ministers. In reality, executive powers are vested in the elected government, which is responsible to the legislature and to the people also. The same points വീണ്ടും വന്നു 2016. അത് നമാം റേബിയ വേഴ്സസ് ഡെപ്യൂട്ടി സ്പീക്കർ ആ കേസിൽ വന്നു. The Supreme Court again said that the governor can act only on the advice of the Council of Ministers. The Supreme Court further stated that the role of the governor ends with the summoning of the House, so far as the Assembly is concerned. The Supreme Court stated that a governor cannot have an overriding authority over the representatives of the people who constitute the state legislature, or even the executive government functioning under the Council of Ministers with the Chief Minister as the head. Clear ആണ്. ഈ 2016 സുപ്രീം കോടതി ജഡ്ജ്മെന്റ് ഈ 74 ഫസ്റ്റ് കേസിൽ തന്ന ഡിസിഷൻ തന്നെയാണ് പറഞ്ഞിരിക്കുന്നത്. ഇനി നമ്മുടെ ഈ പഴയ അഡ്മിനിസ്ട്രേറ്റീവ് റീഫോംസ് കമ്മീഷൻ 1968 കൊടുത്തൊരു റിപ്പോർട്ട്, it highlighted that the appointment of the governor should not be made based on political affiliation that would undermine his office. It also recommended that the governor's report on president's rule should be based on subjectivity. പൊളിറ്റിക്കൽ അഫിലിയേഷൻ ഇല്ലാതെ ഗവർണറെ അപ്പോയിന്റ് ചെയ്യണമെന്ന് പറഞ്ഞാൽ ഒരു ഗവൺമെൻറ്റും അങ്ങനെ ഒരു ഗവർണറെയും അപ്പോയിന്റ് ചെയ്യില്ല പൊളിറ്റിക്കൽ അഫിലിയേഷൻ ഇല്ലാത്ത. ഇപ്പോൾ ഒരു ബ്യൂറോക്രാറ്റിനെ വെച്ചാലും അല്ലെങ്കിൽ IPSകാരെയും IASകാരെയും റിട്ടയർ ചെയ്തവരെ വെച്ചാലും ജഡ്ജിമാരെ വെച്ച് കഴിഞ്ഞാലും അതിൻ്റെയൊക്കെ റിസൾട്ട് ആരാണ് അപ്പോയിന്റ് ചെയ്യുന്നത്, ഏത് ഗവൺമെൻറ്റാണ് അപ്പോയിന്റ് ചെയ്യുന്നത്, ആ സെൻട്രൽ ഗവൺമെൻറ്റിനോടുള്ള അവർ പറയുമ്പോൾ അവർ പറയുന്നത് ചെയ്യാൻ വേണ്ടിയിട്ട്, ഇല്ലെങ്കിൽ അയാൾ ഏത് സമയത്തും ഗവർണറെ വിഡ്രോ ചെയ്യാനുള്ള പവേഴ്സ് കൂടി ഗവൺമെൻറ് ഓഫ് ഇന്ത്യക്ക് ഉള്ളതുകൊണ്ട് ആരെ വെച്ചാലും താല്പര്യമുള്ള ആളുകളെ മാത്രമേ വയ്ക്കുകയുള്ളൂ. ഈ പൂഞ്ചി കമ്മീഷൻ കുറേ രസകരമായ കുറേ കാര്യങ്ങൾ പറഞ്ഞിട്ടുണ്ട്. നമുക്ക് അക്സെപ്റ്റ് ചെയ്യാൻ പറ്റുന്ന കാര്യങ്ങൾ എല്ലാമല്ല, പക്ഷെ ഞാനത് ആ റെക്കമെൻഡേഷൻസാണ് ഗവർണറുടെ അപ്പോയിൻമെൻറ്റിനെ സംബന്ധിച്ച് പൂഞ്ചി കമ്മീഷൻ പറഞ്ഞിരിക്കുന്നത്. The incumbent should have stayed away from active politics even at the local level for at least 2 years prior to his appointment. എന്താ കാര്യം, എന്താ അതിൻ്റെ റിസൾട്ട്, എന്താ ഔട്ട്കം എന്താ? 2 കൊല്ലം മുമ്പ് രാഷ്ട്രീയ പ്രവർത്തനം നിർത്തിയ ഒരാളെ വെച്ച് കഴിഞ്ഞാൽ ഒരു വ്യത്യാസമില്ല. The state chief minister should have a say in the governor's appointment. ഒരു കേന്ദ്ര ഗവൺമെൻറ് സമ്മതിക്കാൻ പോകുന്ന ഒരു കാര്യമല്ല. ഇനി കേന്ദ്രത്തിൽ അധികാരത്തിലിരിക്കുന്ന കക്ഷികൾ തന്നെയാണ് ഇന്ത്യയിലെ എല്ലാ സംസ്ഥാനത്തും ഭരിക്കുന്നതെങ്കിൽ പോലും ചീഫ് മിനിസ്റ്റർമാർക്ക് ഗവർണർമാരെ അപ്പോയിന്റ് ചെയ്യാൻ ഒരു സേ വേണം എന്നുള്ളത് ഒരു സെൻട്രൽ ഗവൺമെൻറ്റും സമ്മതിക്കാൻ പോകുന്നില്ല. മൂന്നാമത്തേത്, there should be a committee entrusted with the appointment of governors. The committee should comprise of the Prime Minister, the Home Minister, Speaker of the Lok Sabha and the concerned state chief minister. ഇതൊരു പ്രാക്ടിക്കലായിട്ടുള്ള ഒരു പ്രപ്പോസൽ അല്ല. The doctrine of pleasure should be deleted from the constitution. അത് നല്ല സജഷനാണ്. കാരണം ഈ ഡോക്ട്രൈൻ ഓഫ് പ്ലഷർ എന്ന് ഭരണഘടനയിൽ എഴുതി വയ്ക്കുകയും നമ്മളത് ഇൻ്റർപ്രറ്റ് ചെയ്യുമ്പോൾ ഗവർണറുടെ ഒരു ഇൻഡിവിജ്വൽ ആയിട്ടുള്ള പ്ലഷർ അല്ല എന്ന് വ്യക്തമാവുകയും അത് പിന്നീട് വന്ന കേസുകളിലെല്ലാം ഒരു ഗവൺമെൻറ്റിനെ പിരിച്ചുവിടാൻ പോലും ഉള്ള അധികാരം ഗവർണർക്കില്ല. ഇപ്പോൾ SR ബോംബെ കേസിൽ കൃത്യമായിട്ടുള്ള ഗൈഡ് ലൈൻസ് ഉണ്ട്. ഫ്ലോറിൽ ഭൂരിപക്ഷമുള്ള ഒരു ഗവൺമെൻറ്റിനെയും ഒരു ഗവർണർക്കും പിരിച്ചുവിടാൻ കഴിയില്ല, റെക്കമെൻഡ് ചെയ്യാൻ കഴിയില്ല. പിന്നെ അതിനകത്ത് കുറേ കാര്യങ്ങൾ പറയുന്നത് ഇതൊന്നും ഒരു റെലവൻ്റ് ആയിട്ടുള്ള കാര്യങ്ങളല്ല. അതുകൊണ്ട് ഞാൻ അത് മുഴുവൻ അത് വായിക്കുന്നില്ല. പിന്നെ ഉള്ളത് ബില്ലുകളെ സംബന്ധിച്ചിട്ടുള്ള ലീഗൽ പൊസിഷനാണ്. ബില്ലുകളെ സംബന്ധിച്ച് ഇപ്പോൾ ഉള്ള പ്രശ്നം എന്ന് വെച്ച് കഴിഞ്ഞാൽ that most governments have is the governor's prolonged inaction when a bill that has been lawfully passed by the legislature is given for assent. Governor simply waits without making a choice. Article 200 of the Constitution provides 4 options to the governor. These options are to give assent, withhold assent, return the bill to the assembly for reconsideration, or reserve it for the consideration of the president. The governor is obliged to exercise any of these options as soon as possible so that the legislative process achieves finality. By not using any of the aforementioned options, governors cause a disruption in this constitutional system. ബില്ല് പാസ്സാക്കുന്നത് ലെജിസ്ലേച്ചറാണ് അല്ലേ? ലെജിസ്ലേച്ചർ പാസ്സാക്കിയ ബില്ലിനെ ഗവർണർക്ക് റിസർവ് ചെയ്ത് വെക്കാൻ, ദീർഘകാലത്തേക്ക് വെക്കാനുള്ള ഒരു അധികാരവും ഇല്ല എന്നാണ് എൻ്റെ അഭിപ്രായം. ഇതിൽ തന്നെ പറയുന്നുണ്ട് തിരിച്ചയക്കാം. തിരിച്ചയച്ചാൽ എന്തെങ്കിലും കംപ്ലൈൻറ്റ് പറഞ്ഞിട്ട് തിരിച്ചയക്കാം. തിരിച്ചയച്ചാൽ പോലും ലെജിസ്ലേച്ചറിന് വിത്തൗട്ട് മേക്കിംഗ് എനി അമെൻമെൻറ്റ് the legislature can send it back. Then he has to sign. Governor has to sign. വേറെ ഓപ്ഷൻ ഇല്ല. അമെൻമെന്റ് ഇല്ലാതെ തന്നെ തിരിച്ചയക്കാം. ആദ്യം അയച്ച അതേ പൊസിഷനിൽ തന്നെ രണ്ടാമത് ലെജിസ്ലേച്ചറിന് അയക്കാം. അങ്ങനെ തന്നെ വേണമെങ്കിൽ അമെൻഡ് ചെയ്തിട്ട് അയക്കാം. അമെൻഡ് ചെയ്യാതെ അയച്ചാലും ഗവർണർ സൈൻ ചെയ്യണം. ഒറ്റ പ്രാവശ്യം തിരിച്ചയക്കാനുള്ള പവർ ഉള്ളൂ യഥാർത്ഥത്തിൽ. പിന്നെ ചെയ്യാൻ പറ്റാവുന്നൊരു കാര്യം റിപ്പഗ്നൻസി പറഞ്ഞ്, സെൻട്രൽ ലോയുമായിട്ടുള്ള റിപ്പഗ്നൻസി പറഞ്ഞ് പ്രസിഡൻഷ്യൽ അസെന്റിന് വേണ്ടി അയക്കാം. അതും അതിനൊക്കെ ഒരു ടൈം ലിമിറ്റ് ഉണ്ടാകണം എന്നാണ് എൻ്റെ അഭിപ്രായം. പ്രസിഡൻഷ്യൽ അസെന്റിന് പോയാൽ ഇൻഡെഫിനിറ്റ് ആയിട്ട് ബില്ല് അവിടെ കിടക്കും. റിപ്പഗ്നൻസി ഉണ്ടെങ്കിൽ സെൻട്രൽ ലോയുമായിട്ട് ഇൻകൺസിസ്റ്റന്റ് ആയിട്ടുള്ള പ്രൊവിഷൻസ് ഏതെങ്കിലും സ്റ്റേറ്റ് പാസ്സാക്കിയേക്കുന്ന ലെജിസ്ലേഷനിലുണ്ടെങ്കിൽ അത് ചൂണ്ടിക്കാണിക്കാതെ നിൽക്കില്ല. അതിപ്പോൾ കോടതിയുടെ റിവ്യൂവിലും വന്നു കഴിഞ്ഞാൽ നിൽക്കില്ലല്ലോ, ഒരു കാരണവശാലും നിൽക്കില്ല. ഇപ്പോൾ പാസ്സാക്കിയ ഇപ്പോൾ ഈ യൂണിവേഴ്സിറ്റി വൈസ് ചാൻസലറെ റിമൂവ് ചെയ്ത നമ്മുടെ ടെക്നിക്കൽ യൂണിവേഴ്സിറ്റി കേസിൽ അവിടെ ഗവൺമെൻറ്റും ഗവർണറും ഒരുമിച്ചായിരുന്നു ആ കേസിൽ. കാരണം ആ അപ്പോയിൻമെൻറ്റ് കറക്റ്റാണെന്നാണ് പറഞ്ഞത്. സുപ്രീം കോടതി പറഞ്ഞു UGC റെഗുലേഷൻ അതാണ് പ്രിവൈൽ ചെയ്യുള്ളൂ. ഇവിടെ സ്റ്റേറ്റ് പാസ്സാക്കിയ ആക്ട് അല്ല നിൽക്കുന്നത്. വേർ ദർ ഈസ് എ സെൻട്രൽ ലോ, അതുമാത്രം പ്രിവൈൽ ചെയ്യുള്ളൂ എന്ന് സുപ്രീം കോടതി പറഞ്ഞുകൊണ്ടാണ് ടെക്നിക്കൽ യൂണിവേഴ്സിറ്റിയിലെ VCA ചെയ്തത്. അവിടെ ഗവർണറും ഗവൺമെൻറ്റും ഒരുമിച്ചാണ് പറഞ്ഞത് ഇത് ഈ സ്റ്റേറ്റ് ആക്ട് അനുസരിച്ചിട്ടാണ് പാസ്സാക്കിയത്, അവിടെ നിൽക്കുകയുള്ളൂ എന്ന് പറഞ്ഞത് ഒരുമിച്ചാണ്. അപ്പോൾ ബില്ലുകളെ പാസ്സാക്കുന്നതിനെ സംബന്ധിച്ചിട്ടുള്ള ലീഗൽ പൊസിഷൻ വളരെ ക്ലിയറാണ്. ഒരു കാരണവശാലും ലെജിസ്ലേച്ചർ പാസ്സാക്കുന്നത് നിയമപരമായിട്ടുള്ള ബില്ലാണെങ്കിൽ അത് സൈൻ ചെയ്യാനുള്ള ഉത്തരവാദിത്വം ഗവർണർക്കുണ്ട്. അപ്പോൾ യഥാർത്ഥത്തിൽ തോമസ് ഐസക്കും ഞാനും തമ്മിൽ ഗവർണറുടെ അധികാരങ്ങളെ സംബന്ധിച്ച് തർക്കമില്ല. ഞങ്ങൾ ഒരുമിച്ചൊരു യോഗത്തിൽ സംസാരിച്ചപ്പോൾ ഒരു തർക്കമില്ല ഗവർണറുടെ അധികാരങ്ങളെ സംബന്ധിച്ച്. ഗവർണർക്ക് അങ്ങനെയുള്ള ഒരു ഡിസ്ക്രിഷണറി പവർ കൗൺസിൽ ഓഫ് മിനിസ്റ്റേഴ്സിൻ്റെ അതുകൊണ്ടാണ് ബാലഗോപാൽ ഫിനാൻസ് മിനിസ്റ്ററോട് പ്ലഷർ പോയെന്നും പറഞ്ഞുകൊണ്ട് ലെറ്റർ മുഖ്യമന്ത്രിക്ക് കൊടുത്തപ്പോൾ ഞാൻ ഫസ്റ്റ് റിയാക്ട് ചെയ്ത് ഗവർണർക്ക് അതിനുള്ള അധികാരമില്ല. ഗവർണർക്ക് അതിനുള്ള അധികാരമില്ല. ഗവർണറുടെ ഒരു ഇൻഡിവിജ്വൽ പ്ലഷർ അല്ലല്ലോ, അദ്ദേഹത്തിന് ഇഷ്ടമില്ല എന്ന് പറഞ്ഞിട്ട് വിഡ്രോ ചെയ്യാൻ ചീഫ് മിനിസ്റ്ററുടെ പ്രഷറാണ് മന്ത്രി വിഡ്രോ ചെയ്യാൻ വേണ്ടിയിട്ട്. അല്ലാതെ ഗവർണർക്ക് യാതൊരു പ്ലഷറും ഇല്ല. ഗവർണർക്ക് ഒരു അധികാരം ഒരു മന്ത്രിയെ വിഡ്രോ ചെയ്യാനോ ഒരു ഗവൺമെന്റിനെ പിരിച്ചുവിടാനോ അല്ലെങ്കിൽ ഗവൺമെന്റിന്റെ ഇന്റേണൽ മാറ്റേഴ്സിൽ ഇന്റേണൽ ഗവേണൻസിൽ ഇന്റർഫിയർ ചെയ്യാനുള്ള ഒരു അധികാരമില്ല. അത് കോൺസ്റ്റിറ്റ്യൂവന്റ് അസംബ്ലി തൊട്ട് വളരെ ക്ലിയർ ആയിട്ടുള്ള കാര്യങ്ങൾ. അത് ഞങ്ങൾ തമ്മിൽ തർക്കമില്ല. തർക്കം എവിടെയാണ്? സ്റ്റേറ്റ് കോൺസ്റ്റിറ്റ്യൂഷനായിട്ട് ബന്ധപ്പെട്ടതല്ല തർക്കം. കോൺസ്റ്റിറ്റ്യൂഷന് ഞങ്ങൾ ഒരുമിച്ചാണ്. കോൺസ്റ്റിറ്റ്യൂഷൻ പറയുന്ന കാര്യങ്ങളല്ലേ. ചാൻസലർ എന്നുള്ള പദവി ഗവർണർക്ക് കിട്ടിയിരിക്കുന്നത് ആര് കൊടുത്തിരിക്കുന്ന? സ്റ്റേറ്റ് ലെജിസ്ലേച്ചർ കൊടുത്തിരിക്കുന്ന പവേഴ്സ് അല്ലേ. അവിടെ ഗവർണർ ആക്ട് ചെയ്യണമെന്നാണ് ഞങ്ങളുടെ നിലപാട്. സ്റ്റേറ്റ് കൊടുത്തിരിക്കുന്ന സ്റ്റാറ്റ്യൂട്ടറി പവേഴ്സ് ഇപ്പോൾ കണ്ണൂർ യൂണിവേഴ്സിറ്റിയുടെ സെക്ഷൻ 10 എന്താ പറയുന്നത്? ദ ചാൻസലർ ഷാൽ കോൺസ്റ്റിറ്റ്യൂട്ട് ദ സെർച്ച് കമ്മിറ്റി. ചാൻസലറാണ് കമ്മിറ്റി സെർച്ച് കമ്മിറ്റി എങ്ങനെയാണ് ഫോം ചെയ്യേണ്ടത് എന്നുള്ളത് UGC റെഗുലേഷൻസ് പറയുന്നുണ്ട്. UGC റെഗുലേഷൻ പറഞ്ഞ് സെർച്ച് കമ്മിറ്റി ഫോം ചെയ്ത് ആ സെർച്ച് കമ്മിറ്റിയാണ് UGC റെഗുലേഷൻ അനുസരിച്ചും നമ്മുടെ സ്റ്റാറ്റ്യൂട്ട് അനുസരിച്ചും വൈസ് ചാൻസലറെ അപ്പോയിന്റ് ചെയ്യേണ്ടത്. അപ്പോഴാണ് ഒരു അധികാരമില്ലാത്ത അവിടെ ഗവൺമെന്റിന് ഒരു അധികാരമില്ല. യൂണിവേഴ്സിറ്റി ഓട്ടോണമസ് ബോഡിയാണ്, ഗവൺമെന്റിന് ഒരു അധികാരമില്ല. പ്രോ ചാൻസലർ എന്നുള്ള പൊസിഷനുണ്ട് സ്റ്റാറ്റ്യൂട്ടിൽ. ആർക്ക്? വിദ്യാഭ്യാസ മന്ത്രിക്ക്, ഹയർ എഡ്യൂക്കേഷൻ മിനിസ്റ്റർക്ക്. വേറെ അധികാരങ്ങളൊന്നുമില്ല. അവിടെ നിന്ന് പ്രോ ചാൻസലർ ഒരു ലെറ്റർ എഴുതുവാണ്. ആർക്ക്? ചാൻസലർക്ക്. അതായത് ഇപ്പോൾ കോൺസ്റ്റിറ്റ്യൂട്ട് ചെയ്ത ഈ സെർച്ച് കമ്മിറ്റി ക്യാൻസൽ ചെയ്യണം. അപ്പോൾ ഞാൻ പറഞ്ഞു ഒരു അധികാരമില്ല പ്രോ ചാൻസലർ. ഹയർ എഡ്യൂക്കേഷൻ മിനിസ്റ്റർക്ക് സ്റ്റാറ്റ്യൂട്ട് വഴി ചാൻസലർ കോൺസ്റ്റിറ്റ്യൂട്ട് ചെയ്ത സെർച്ച് കമ്മിറ്റി റദ്ദാക്കണമെന്ന് പറയാൻ എന്ത് അധികാരമാണുള്ളത്? ഒരു അധികാരമില്ല. രണ്ടാമതൊരു ലെറ്റർ വന്നു. അപ്പോൾ ഗവർണർ ഇത് റദ്ദാക്കി. ഏത്? ഇല്ലാത്ത അധികാരം. ഗവർണർക്ക് അത് റദ്ദാക്കാൻ പാടില്ല. പ്രോ ചാൻസലറുടെ കത്തിൻ്റെ പുറത്ത് ചാൻസലർക്ക് അദ്ദേഹം കോൺസ്റ്റിറ്റ്യൂട്ട് ചെയ്ത സെർച്ച് കമ്മിറ്റി ക്യാൻസൽ ചെയ്യാൻ പാടില്ല. രണ്ടുപേരും തെറ്റ് ചെയ്തു. വീണ്ടും പ്രോ ചാൻസലറുടെ ഒരു ലെറ്റർ, നിലവിലെ വൈസ് ചാൻസലറെ റീഅപ്പോയിന്റ് ചെയ്യണം. അപ്പോൾ നമ്മൾ പറഞ്ഞു അതും ചെയ്യാൻ പാടില്ല. നിലവിലെ വൈസ് ചാൻസലർക്ക് വേണമെങ്കിൽ പുതിയ പ്രോസസ്സ് വരുമ്പോൾ, പുതിയ VCയെ സെലക്ട് ചെയ്യാനുള്ള പ്രോസസ്സ് വരുമ്പോൾ അപ്ലൈ ചെയ്യാം. പക്ഷെ അപ്ലൈ ചെയ്യാൻ പറ്റില്ലായിരുന്നു. കാരണം അദ്ദേഹത്തിന് 61 വയസ്സായിരുന്നു. അത് പിന്നീടാണ് അവർക്ക് മനസ്സിലായത്. 60 വയസ്സ് ആണ് പ്രായപരിധി. 61 വയസ്സ് വീണ്ടും അപ്ലൈ ചെയ്യാൻ പറ്റാത്തതുകൊണ്ടാണ് ഗവൺമെൻറ് യൂണിവേഴ്സിറ്റി കാര്യത്തിൽ ഇടപെട്ട് സെർച്ച് കമ്മിറ്റി റദ്ദാക്കി ആൾക്ക് റീഅപ്പോയിൻമെൻറ്റ് കൊടുത്ത്. സെർച്ച് കമ്മിറ്റി ഇരിക്കുകയാണെങ്കിൽ ആ പ്രോസസ്സ്, അപ്പോൾ അത് സ്റ്റാറ്റ്യൂട്ട് വഴിയുള്ള ഒരു പ്രോസസ്സ് ചെയ്യാൻ ഉത്തരവാദിത്തപ്പെട്ട ഗവർണർ അത് ചെയ്തില്ല. അവിടെയാണ് ഞങ്ങൾ ഡിസ്പ്യൂട്ട് ചെയ്തത്. ഗവർണറും ഗവൺമെൻറ്റും നിയമവിരുദ്ധമായി പ്രവർത്തിച്ചു എന്നായിരുന്നു ഞങ്ങളുടെ പോയിന്റ്. അതായിരുന്നു ആ കാര്യത്തിലാണ് അഭിപ്രായ വ്യത്യാസമുള്ളത്. നേരത്തെ പറഞ്ഞ കോൺസ്റ്റിറ്റ്യൂഷണൽ പവേഴ്സിൻ്റെ കാര്യത്തിൽ ഒരു അഭിപ്രായ വ്യത്യാസമില്ല. പൊതുവായിട്ടുള്ള നിലപാടാണ്. ഇപ്പോൾ എൻ്റെ പാർട്ടി ഓൾ ഇന്ത്യ തലത്തിൽ എടുത്തിരിക്കുന്ന നിലപാട് അത് തന്നെയാണ്. ഒരു വ്യത്യാസമില്ല. ഒരേ സ്റ്റാൻഡാണ് എടുത്തിരിക്കുന്നത്. ഇവിടെ വന്നു കഴിഞ്ഞപ്പോൾ ഈ നിയമം മറികടക്കാൻ വേണ്ടി ശ്രമിച്ചപ്പോഴാണ് പറഞ്ഞത്. അപ്പം we have been consistently arguing that all these appointments were irregular and illegal because it violated the UGC regulations. അപ്പോൾ സുപ്രീം കോർട്ട് ഞങ്ങളുടെ ആർഗ്യുമെന്റ്സിനെ എൻഡോസ് ചെയ്തു. ഞങ്ങൾ കഴിഞ്ഞ ഒരു വർഷമായിട്ട് പറഞ്ഞുകൊണ്ടിരുന്ന all these appointments were void ab initio എന്ന് സുപ്രീം കോർട്ട് വിധി വന്നു. അതാണ് ഞാൻ കമന്റ് ചെയ്തത്. ഗവർണറും ഗവൺമെന്റും തോറ്റു സുപ്രീം കോർട്ടിൽ, ജയിച്ചത് ഞങ്ങളാണെന്ന് പറഞ്ഞു. അതാണ് ഇതൊക്കെ ഈ ഗവർണറുടെ നമ്മുടെ സബ്ജക്റ്റിന്റെ പുറത്തുള്ള കാര്യങ്ങളാണ്. ഗവർണറുടെ കോൺസ്റ്റിറ്റ്യൂഷണൽ പവേഴ്സിന് പുറത്തുള്ള കാര്യങ്ങളാണ്. ഗവർണർക്ക് ഗവൺമെന്റും ലെജിസ്ലേച്ചറും കൊടുത്ത സ്റ്റാറ്റ്യൂട്ടറി പവേഴ്സിലാണ് ഈ തർക്കമുള്ളത്. കോൺസ്റ്റിറ്റ്യൂഷണൽ പവേഴ്സിലല്ല തർക്കം. അപ്പോൾ അതുകൊണ്ടാണ് ആ കാര്യത്തിൽ ഞങ്ങൾ വോയിഡ് അബ് ഇനിഷ്യോ ആണെന്ന് സുപ്രീം കോർട്ട് പറഞ്ഞു കഴിഞ്ഞാൽ പിന്നെ ഫൈറ്റ് ചെയ്ത് നിന്നിട്ട് കാര്യമുണ്ട്. ഇതിൽ കുറേ അക്കാഡമിക് ബ്രില്യൻസ് ഉള്ള ആളുകളുണ്ട്, നല്ല ഇതായിട്ടുള്ള ആളുകളുണ്ട്, നല്ല കൊള്ളാവുന്ന ആളുകളുണ്ട്, കുറേ പേര് അർഹതയില്ലാത്ത ആളുകളുണ്ട്. അപ്പോൾ അതുകൊണ്ടാണ് ഞങ്ങൾ അവർ റിസൈൻ ചെയ്യണം എന്നുള്ള സ്റ്റാൻഡ് എടുത്തത്. റിസൈൻ ചെയ്തിട്ട് സെൻട്രൽ ലോ അനുസരിച്ചുള്ള പ്രൊസീജിയർ അനുസരിച്ച് പുതിയ ഈ സെർച്ച് കമ്മിറ്റി കോൺസ്റ്റിറ്റ്യൂട്ട് ചെയ്ത് പുതിയ വൈസ് ചാൻസലർമാർ വന്നോട്ടെ. ആ കൂട്ടത്തിൽ ഇതിൽ അർഹതയുള്ള ആളുകൾ അവർ വന്നോട്ടെ, അതിൽ നമുക്ക് വിരോധമില്ല. അതുകൊണ്ടാണ്. അപ്പം അത് ഭയങ്കരമായിട്ട് തെറ്റിദ്ധരിക്കും. കാരണം മീഡിയയാണ് കൺഫ്യൂഷൻ ഉണ്ടാക്കുക. മീഡിയയുടെ ക്വസ്റ്റ്യൻ ഇതാണ്: നിങ്ങൾ ഗവർണറുടെ കൂടെയാണോ, നിങ്ങൾ മുഖ്യമന്ത്രിയുടെ കൂടെയാണോ? അതൊരു ശരിയായ ചോദ്യമല്ല, അതൊരു തെറ്റായ ചോദ്യമാണ്. അതിൽ കുറേ പേര് തലവെച്ചു കൊടുത്തു അറിയാതെ. മനസ്സിലായില്ലേ? അപ്പോൾ ഞാൻ കുറച്ചുകൂടി ക്ലാരിറ്റി വരുത്താൻ വേണ്ടിയിട്ടാണ് ഞാൻ പറഞ്ഞത്. ഗവർണറെ സംബന്ധിച്ച കോൺസ്റ്റിറ്റ്യൂഷണൽ പവേഴ്സ് ഒരു ഡിസ്ക്രിപ്ഷനും ഇല്ല. അദ്ദേഹത്തിന് കൗൺസിൽ ഓഫ് മിനിസ്റ്റേഴ്സിൻ്റെ അഡ്വൈസ് ഇല്ലാതെ ഒരു കാരണവശാലും ഇടപെടാൻ പാടില്ല എന്നാണ്. പിന്നെ ഗവർണർ പദവി വേണോ വേണ്ടേ എന്നുള്ള കാര്യം പാർട്ടി ഡിസ്കസ് ചെയ്തിട്ടില്ല. ഞാൻ ഓഫ് ഹാൻഡായിട്ട് ഒരു അഭിപ്രായം പറയാൻ പറ്റില്ല. പാർട്ടി അത് ചർച്ച ചെയ്യും. മോഹൻ ഗോപാൽ സാറിന് പറയാം. എൻ്റെ വ്യക്തിപരമായ അഭിപ്രായം അത് വേണ്ടെന്നാണ്. പാർട്ടിയിൽ ഏതെങ്കിലും സമയത്ത് ഒരു ഡിസ്കഷൻ നടക്കുമ്പോൾ അത് നമ്മൾ ഒരു കാരണവശാലും അത് സംസാരിക്കില്ല. ഇതേ പാർവതി, ഇത് സബ്ജുഡീസ് ആയിട്ടുള്ള കാര്യമല്ല പറഞ്ഞത്. സബ്ജുഡീസ് ആയിട്ടുള്ള കാര്യമാണ്. സബ്ജുഡീസ് അല്ല, സുപ്രീം കോടതി വേർഡിക്റ്റ് വന്ന കാര്യം പറഞ്ഞു. ഫൈനൽ വേർഡിക്റ്റ്. ഞാൻ അതിൻ്റെ മീതെ വേറെ ഒന്നുമില്ലല്ലോ. സുപ്രീം കോടതിൻ്റെ ഫൈനൽ വേർഡിക്റ്റ് വന്ന കേസാണ്. അത് സബ്ജുഡീസ് ആവില്ല. അങ്ങനെ സബ്ജുഡീസ് ആവുന്നത് അത് വേണേൽ നമുക്ക് ആർഗ്യൂ ചെയ്യാം, ഡിബേറ്റ് ചെയ്യാം. അതാവില്ല. ഫൈനൽ വേർഡിക്റ്റ് സുപ്രീം കോടതിൻ്റെ അത് എന്താണ്, ലോ ഓഫ് ദ ലാൻഡ് അല്ലേ, ഫൈനലാണ്, സബ്ജുഡീസ് ആവില്ല. അപ്പോൾ ഇതാണ് നമ്മളെ കൃത്യമായിട്ടുള്ള അഭിപ്രായം. ഗവർണറെ സംബന്ധിച്ചുള്ള തർക്കങ്ങളിൽ ഈ തർക്കങ്ങളാണ് ഉള്ളത്. അതുകൊണ്ട് നമ്മുടെ കോൺസ്റ്റിറ്റ്യൂഷൻ വളരെ ക്ലിയറാണ്. പക്ഷെ അതിനകത്ത് ഈ 163 ഉള്ള ഈ ഡിസ്ക്രിഷൻ എന്നുള്ളത് ഒരു അമെൻമെൻറ്റ്, കോൺസ്റ്റിറ്റ്യൂഷണൽ അമെൻമെൻറ്റ് കൊണ്ടുവന്നു. ആ ഡിസ്ക്രിഷൻ എന്നുള്ളത് കുറച്ചുകൂടി ക്ലാരിറ്റി വരുത്തി അത് കളയണം എന്നുള്ളൊരു അഭിപ്രായം കൂടി ഞാൻ പ്രകടിപ്പിച്ചുകൊണ്ട് വാക്കുകൾ ചുരുക്കുന്നു.
Thank you very much, Mr. Satishan. May I request Dr. Thomas Isaac to share his thoughts with us.
Dr. Mohan Gopal, respected V.D. Satishan, Advocate B.G. Harindranath, and members of the Kerala High Court Advocates Association and Constitutional Debate Club. Normally, myself and V.D. Satishan rise to oppose each other. So till he reached the fag end of his talk, I was wondering for the first time, I'd love to support him throughout the speech. All the points you made. Luckily, I am saved. That there is a point of we can differ. Of course, with all respects, as usual. But let me start with the main. Since the constitutional provisions, say interpretations given by in the Constitutional Assembly, and also judgments of Supreme Courts have been elaborately quoted, I shall dispense with any quotations in my speech. I'll keep it to a very simple logic. How do we make an assessment of the constitutional provisions of the governor and its interpretations? Now, interpretations are very important because some of the provisions in the Constitution, despite what Ambedkar elaborated in the Constituent Assembly, are ambiguous. And that's why Supreme Court had to clarify. And that's why Punji Committee in the report said Constitution must be amended to remove the ambiguities and give full clarity. Therefore, interpretations also have to be assessed. How do we do that? I think it must be with reference to two cardinal points of structure of the Constitution, basic structure of the Constitution. One, our parliamentary democratic system. Two, our federal structure. Now, democratic system can be either presidential or parliamentary cabinet system. We have followed the latter. And now, having chosen that, that's what, though of course you can have a situation where of not having a governor, but you need an entity which would determine who has the majority in the assembly, legislature, who would swear in and then see, continuously monitor if they continue to enjoy the majority, dissolve the assembly if necessary, prorogue the assembly if necessary, call for a vote of confidence. Therefore, normally you find in all parliamentary systems to have a nominal head. There's a real executive, but then the nature of parliamentary system is such that in between the tenure, governments can change, and therefore need for a constitutional figurehead. Now, many radical people have taken the position that Mohan Gopal took, that the position of governor can be dispensed with. But for the reason that Mohan Gopal touched upon, that the constitution itself is facing a major challenge from the political sphere, I wouldn't want to disturb it further by demanding a change in the important institution that is there in the constitution. So, having accepted along with the framework, the frameworkers of the constitution, that there is such a position of governor, then the nature of the kind of powers of the governor, that would be determined also along with the context of federalism, you see. Because governor is being appointed. In fact, Ambedkar takes the position, it doesn't matter whether he is elected or nominated. In fact, if he is elected, that will create problem. There are two elected people, the chief minister as well as the governor, he is also elected. There will be tussle of power. But whether he is selected or nominated, when he is nominated by the center to head a federal provincial unit. And that can give rise to center-state conflicts. Then, as Sadish said, it doesn't matter at all as long as the center and states are ruled by the same party. Therefore, until 1967, except for a brief situation in Kerala in 1959, system worked fairly well. But 1967 changed. So you will find a large number of states, non-Congress governments coming into power. You will find between 1967 and 72 around 24 governments changed. And therefore there gave rise to conflicts regarding the many questioning partiality of the governor and so on. But 1977 brought in yet another major change. You see. You had then the government of the center itself changing. Each time a political change came about in center, they would want to make and unmake their governors. They would want to bring in their political nominees as the governors. Doesn't matter who was in power. Everybody did the same. So the position, role of the governor became even more politicized. So the federalism was under threat, under terrific tension, let me put it that way. And to mediate this tension, in fact, 3 commissions went into examine the whole center-state relations. One was the Sarkaria Commission, then came the Commission to review the constitutional working, and third, the Punji Committee. Now, if you look, it's very interesting. You compare the 3 reports. The reports, in fact, Sarkaria Commission, despite it is very famous, has been conservative. Very minor changes they are suggesting. But when you move forward in the committee to review the working of the Constitution, there's a Punji Committee, they become more radical. In fact, Punji Committee wants constitutional amendments to the power of the governor. But you told is very true, Sadish. I mean, those changes, consultation, etc., is not going to give the word. But nevertheless, there's a process of consultation. You not unilaterally you decide whom to send to Kerala, send to others. I think certain guidelines would have to come. So these commissions went to it. So we have now 1, constitutional debates to understand what are the provisions of the Constitution. 2, the interpretations and suggestions of these committees. And 3, decisions of Honorable Court. And one emergence from all these discussions, what emerges is that something I think needn't be elaborated upon. He's a formal head. Real executive of the government is the cabinet responsible to the legislature. I don't think there is anybody who would seriously challenge that. That's a settled issue. But then comes the question which Sudhishan raised, the discretionary power of the governor. As he rightly said, in 1935 Constitution, almost every clause of the governor had in his discretion. In fact, in 1937 election, that's when this 1935 Act became operational, Congress has first refused to swear in until they got the assurance from the Governor General that this discretion won't be used. I don't know how much was kept and so on, but Congress made it an important political point that we won't join unless and until the discretion of the governor is. Therefore, in Constitution was adopted later. 1935 Act continued to govern the independent India. But one thing that was done was, wherever that indiscretion of the governor was there, was changed to as advised by the cabinet. Very systematically, in the adaptation, this was changed. And as Satish said, there is a whole debate whether you need a discretion. Finally, whatever the system, the wisdom, they decided to have discretion for the governor. But that discretion is not open-ended. 163(1), yes, cabinet to aid and advise the governor. Then there is 163(2), where it is very specifically said what is the discretion about. It is said that as directed by and under the Constitution. So very important three terms here. One, discretion is as directed by Constitution, and again by and under. So it's extremely limited. Explicitly where Constitution gives discretion, that discretion he has. And what is the discretion? That discretion is to decide what Mohan Gowal said about who is to be the chief minister, who has the majority. Okay, Supreme Court has set certain modalities in determining that. Whether they continue to enjoy the majority. The Bombay case, it has been said, it has been tested in the assembly, floor of the assembly. And then the advice of he has discretion in determining the house to be prorogued or be dissolved. So in this matter, he has discretion. Secondly, he has discretion with respect to northeastern India tribal areas where government of India at that time wanted to give special protection. So you have discretion there. And certain things explicitly said, these are mainly the discretionary powers of the governor. You see. So some governors have come to believe that not the chief minister, but even the ministers can hold office only according to their pleasure. But it's such a laughable proposition. I have counted 6 national dailies have written editorial condemning this position, so that nobody now repeats that. That is gone. But then, what is now being debated in Kerala is with respect to whether a law passed by the legislature, you said 4 options that Punji committee gives. So, okay, you don't give assent, you don't return immediately, as soon as possible. Now, as soon as possible is being interpreted anytime possible. Quoting one case in 1959, which is totally irrelevant in this context. That cannot be carried on to this present situation. I know Purushottam case is a very, very different context altogether. So then what do? You can keep it, not doing anything. That's where the recent judgment in the Tamil Nadu case, Perarival, that Rajiv Gandhi assassination case, the judgment becomes very important. Governor has no right to keep it indefinitely and overcome the will of the people as reflected in the assembly. So he has to send to the president, return to the assembly, or give assent. You cannot hold it indefinitely, months together. In fact, Punji committee, as Satish said, suggested that time limits be put even to the president as well as the governor for his autonomy. So, this is the situation, a point on which a big debate is going on. But I think things are very clear. Except for the time the governor can take. The whole case of Purushottam versus Kerala government has to be revisited. It's a very specific case. Law passed by assembly, sent to the president. Then by the time president looks into it, the government is dismissed. New government comes in 1960, which reenacts it. In between, Purushottam goes for his 900 acres of land, Pandaravaga land, and says that law is not there. So how can he be, the land be taken over? So Supreme Court just looked at that point and said, no. Though governor was not taking a decision, president had not taken a decision, still that act is live. So it is from this decision, made in a peculiar circumstance, any interpretation would have created a serious problem in Kerala, that now somebody is interpreting that governor can keep the law to whatever extent necessary. So now finally a point which I will have to differ from Sadisha. Sadisha? Now a point of difference with you. See, I don't want to go into nitty-gritty of the modality. But what is happening? I was very happy that Mohan Gobal started with a political statement, what is happening in the country as a whole, how the constitution is being subverted and being challenged. What is happening is a major attempt to subvert the entire university education in Kerala. That political point we should not forget. Because we have the situation where somebody was appointed to the medical university by the governor. He is given charge of Kerala University. And next day you find him participating in a political party's cultural meeting, revealing his true character. Now, whether UGC regulation is superior to an act of the assembly is not a settled question. The single bench, division bench in Kerala, dismissed the challenge, went to Supreme Court. Supreme Court upheld the challenge. I don't want to elaborate upon. Today's Hindu, Law Sabha Secretary General Achary's article. He has given 5 points, elaborated it, why this verdict has to be reviewed. 1, the 254, the law referred to it, refers to a substantial law which is sent to the governor or to the president for assent. It does not deal with such. This law is very specific. The terms. And the law passed by the parliament, given assent by the president, does not have any provision regarding appointment of vice chancellor. It comes through, though such a provision is not there, in the subordinate legislation it comes. Every time you have been present anything in the assembly, the suggestion you are the first to challenge. Is that clause open or not? You see. So I always wonder how can it be done. He goes on and therefore he says no. These verdicts have to be looked into. There are other Supreme Court judges. Judgments with somebody from Kerala itself. So anyway, but I'm saying this is not a settled issue. It is being agitated. Kerala government is going to move to the again. Now, meanwhile, what is happening? Meanwhile, you are in a tearing hurry. Displace all the 11. Bring in how? The UGC nominee? The governor's nominee, he is not going to listen to the council because he says he has been given statutory powers in the University Acts to determine his own people. So 2 against 1 Senate representative. We are going to have vice chancellors whose political and ethical and cultural vision Kerala do not accept. You have to accept. Our country is a country of diversity here. People think differently. Not only people, regions think differently. They have different cultural traditions, political visions. That cannot be bulldozed in this manner. Using the instrument of governor. Look, this is not something with Kerala. I shall not elaborate. I don't want to take more time. 20 minutes is over. 1. Delhi and Puducherry. And then you may say Delhi and Puducherry are union territories. But union territories with the elected assembly. After that, Tamil Nadu, Telangana, Maharashtra, Shinde came, Rajasthan, Bengal. See, earlier there used to be some scuffles between center and state. Kerala may oppose somebody there, somebody. That was it's part of, okay, somebody with another persuasion is ruling center. Here, there will be some talk. Now the game has changed. Governor is being used as a political instrument to subvert every non-BJP government in India, you see. That's the game. And that's going to make an entry into Kerala education. When you look at the actions and so on, even law is interpretation. I'm a political being. I look in this specific political context. So my appeal is that we should have a larger vision, understanding about what is going on in the country. So I thank you all very much for giving this opportunity to address you. And it was very rewarding. And certain Harindranath is going to speak something very interesting. Yeah, we had a very interesting relationship when I was the minister. Yeah. So, thank you very much.
Thank you very much, Dr. Isaac, for your intervention. May I now request Advocate B.G. Harindranath to kindly share his thoughts.
Dr. Mohan Gopal, Dr. Sri V.D. Sadishan, Dr. T.M. Isaac, Mr. Rajesh Vijayan, Tushara James, Advocate Enoch, Preeta, Additional Advocates General Ashok Cherian and K.P. Jayachandran, Senior Counsel J.J. Babu, other distinguished members of the bar, my dear friends. Well, I am not intending to go into the controversial aspects. I'll just speak law, whatever I know. Because whether speak law in the sense that I will take you to the drafting of the Constitution, how the role of the governor changed during the Constituent Assembly debates. Now, most of you must have heard of Oliver Wendell Holmes, American Supreme Court judge. He has written a beautiful book, Life, Common Law. In that he says, I quote, "The law embodies the story of a nation's development through many centuries, and it cannot be dealt with as if it contained only the axioms and corollaries of a book of mathematics. In order to know what it is, we must know what it has been and what it tends to become. We must alternately consult history and the existing theories of legislation." This is all the more important to understand the subtle nuances of the Constitution, the role of the governor, how governor's role changed even during the Constituent Assembly debates. Now you would understand, after the freedom struggle, when the Constituent Assembly, members of the Constituent Assembly gathered, they were all for liberty, they were all for freedom. They wanted a strong state, strong center, and a complete break with the English tradition of crime control model. They wanted rule of law, they wanted due process. All this changed. Why did it change? We have to think of the aftermath of the partition. There was strife, struggle, murder, mayhem throughout the country, and there were fissiparous tendencies. Now look at how the Constituent Assembly debates on the position of governor started. I'll just read. On the 15th July 1947, Vallabhbhai Patel, the Home Minister, he moved the first clause of the governor's report. This is what he said. Governor, I move the first clause of the report. Governor, 1. For each province, at that time they called it province, not states. Province, there shall be a governor to be elected directly by the people on the basis of adult suffrage. And then he said how it should be elected, how it should be synchronized, and what should be the modalities. That is what Vallabhbhai Patel said on the 15th of July, 1947. Look at what happened on the 5th November 1948. The drafting committee chaired by Dr. Ambedkar made certain changes. They mooted various proposals, not for election of the governor. Then Bishwanath Das, who was a member from Orissa, he later became the Chief Minister of Orissa, a prominent member, he said, I very strongly oppose the idea of nominated governors. I do not know why the idea of those in which my friend Ambedkar is participating, the government should come into the drafting of the Constitution bill. So he staunchly opposed. So something different was there in the drafting bill, which is not evident from the Constituent Assembly debates. Now you find Ambedkar was supported in various matters by Srimati Dakshayani Velayathan. She was the only Dalit woman, educationist from Kerala. And it is not simply that she went there because she came from the poorer sections of the society. She went there on her own merit, and she participated in entire debates. Now Dakshayani Velayathan says, there is another misnomer in the draft, and that is about the selection or the election of governors. She says, the committee feels that if the governor and chief minister, who is responsible to the legislature, are elected by the people, then there will be friction between the two. but the remedy they have suggested is worse than the disease. There is a panel and the president is to select from the one person as the governor. So it seems that they suggested that 4 persons should be elected by the legislature, and then from the panel the president will select one. Then she said, this is worse than the disease. So she did not support an elected governor, Dakshayani Vela, mind you. Thereafter, the entire scenario changed. The even due process clause, after Benegal Rao went to America, met Felix Frankfurter, the judge of the American Supreme Court, they threw out the due process clause from the Constitution. And it was completely the crime control model, which was advanced by the then Home Minister, Vallabhbhai Patel, which was in the forefront. Now you find that on the 30th May 1949, that is towards the end of the drafting, Sri Brajeshwar Prasad, he moves an amendment, and his reason also I shall read out. That for Article 131, in the draft constitution it was Article 131, later it became 155 of the Constitution of India. He says that for Article 131, the following shall be substituted. Substituted means the words proposed by the Home Minister Vallabhbhai Patel. He says, the governor of the state shall be appointed by the president by warrant under his seal. Warrant under his hand and seal. This is the present mode of appointment of the governor in our constitution. Now why he says, I feel, sir, that in the interest of all India unity and with a view of encouraging centripetal tendencies, it is necessary that the authority of the government of India should be maintained intact over provinces. To say that the president may nominate from panel of names really means restricting the choice of the president. It gives power to the hands of the legislature. It is necessary, sir, that the president should be free from influence of a legislator. I feel that the governor may be from one province or from another province. Personally, I feel that the man from a province should not be appointed in the same province. So therefore, the drafting committee at that point of time in 1949 wanted the president to appoint the governor. There should be no panel, no interference by the state legislature or anybody for that matter. And president, as you know, should act on the advice of the Council of Ministers, Prime Minister and his Council of Ministers. And therefore, it is a centre's man who would be there. Then what the subsequent debates, because of paucity of time, I am not reading all that. It was all for, they wanted a more cohesive union, and there were fissiparous tendencies throughout our country. The Indian cabinet chaired by Prime Minister Jawaharlal Nehru and Vallabhbhai Patel wanted a strong center and not that very strong. In fact, under our constitution, if you look at the administrative relations, if you look at the legislative relations, if you look at the role of the governor, you find that there is a central government's control over that. Why was that? Possibly because there were this, what I said before, fissiparous tendencies, and they wanted to curb that. And that is why, if suppose there are no fissiparous tendencies, obviously there could be a person as a governor from our state itself, but governor under our constitution, as it stands today, is the centre's man. He is the link between the central union government and the state government. And he has varied powers. Obviously, he has powers. But then, you should understand that he has no powers on his own. He cannot act according to his discretion in all matters, except, as Dr. Mohan Gopal put, selection of the person who enjoys the majority, confidence of the house. He can select that person as the chief minister, nothing more. He cannot dismiss a chief minister. He has no power to dismiss a minister. Ministers are appointed only on the recommendation of the chief minister, and he can only be removed on the recommendation of the chief minister. Governor cannot act on his own. That is a settled proposition of law. Now, over the years, as Oliver Wendell Holmes put it, our constitution was discussed, debated and settled by various Supreme Court decisions. That is how law develops. As Tennyson put it, this is also the land of the wise and old renowned, where freedom broadens from precedent to precedent. So we have a lot of precedents which continually have shaped our constitution. I am one for evolution and not for revolution. So because if you throw out everything, you will have nothing, and it will be a big vacuum unless this is a very thought out document. You see, the constitution is a well thought out document. Whether you should curb the powers of the governor or not, ultimately it is for the parliament to decide. It is for the parliament to decide. Unless you have 2/3 majority in the parliament, you cannot do away with the post of the governor. Now, Shamsher Singh's case is the most important judgment which we understand. See, 7 judges, they sat, Krishna Iyer, and the judgment was authored by A.N. Ray CJ. There were 2 judicial officers from Punjab. One is Shamsher Singh and the other is Ishwar Chand. Both, the High Court recommended that they should be removed from service for misdemeanor. And one of them was sitting as a law secretary. And High Court's recommendation, without the aid and advice of the governor, was acted upon by the, aid and advice of the Council of Ministers was acted upon by the governor. They went up to the Supreme Court. And Supreme Court was categoric. They said that at paragraph 10, they said that the governor, under Article 163 of the Constitution, has to take the advice of his Council of Ministers, and when he is exercising executive power of the state, he has no role at all. If you ask me, I will say he is just a rubber stamp. He cannot do otherwise. And these are all justiciable matters. If the governor acts in contrary to the advice of the ministers, you can go to court. You can always go to the High Court or the Supreme Court. That is how the constitutional machinery functions. And therefore, he can only act in accordance with the aid and advice of the Council of Ministers. Now, there are certain discretionary powers vested in the governor, as Dr. Mohan Gopal put it. I am not going in detail into those matters. Discretion, of course, as Lord Camden put it, it is a law of tyrants. So, even if a discretion has to be exercised in very rare situations, and that should be exercised in a very reasonable manner. Now, what is happening in our country with 2 or 3 governors sitting over, squatting on bills which they are not signing or doing that is a different matter. That is not a matter which we can interpret the Constitution. Constitution has to be interpreted as the letter of the Constitution stands, not on the actions of the governor. They may be maverick people in power, and we cannot but help. I'm just... Now, in Shamsher Singh's case, they had pointed out the distinction between the power of the governor and the President of India. See, President of India, in 163 and Article 77, there is a distinction. There, except insofar as the Constitution confers on him according to his discretion, those words are absent insofar as the President is concerned. So if you ask me, the governor in certain areas has much more powers now than the President. Now, whether it is a good thing or not has to be decided either in cases which come before the court by the Supreme Court or by a constitution amendment by the Parliament. Now you see, I just wanted to read a conversation in fact, a sort of a debate between Dr. Rajendra Prasad and Dr. B.R. Ambedkar. Now I am just reading out, just for though the time is less, this would be interesting. Mr. President, that is Rajendra Prasad says, there is another amendment which has been moved by Sardar Hukum Singh, which he says that President may promulgate ordinances after consultation with his cabinet ministers. Honorable Ambedkar says, I am very grateful to you for reminding me about this. The point is that amendment is unnecessary because the President could not act and will not act except on the advice of his Council of Ministers. Where is the provision in the draft constitution which binds the President to act in accordance with the advice of his ministers? Then he points out Article 61.1. That was a drafting initial article which was changed later, renumbered later. President says, it only lays down the duty of the ministers, but it does not lay down the duty of the President to act in accordance with the advice of the ministers. It does not lay down that the President is bound to accept his advice. Is there any other provision in the Constitution? We will not be able to impeach him. Then Dr. Ambedkar says, may I draw your attention to Article 61, which deals with the exercise of the President's function. He cannot exercise any of his functions unless he has got advice. In exercise of his functions, it does not merely say to aid and advise. In exercise of his functions. Now, after that, they inserted one more word in article. I'll just read Article 163. There it is said that there shall be a council of ministers with the chief minister at its head to aid and advise the governor in the exercise of his functions, except in so far as he is by or under this required to exercise his functions or any of them in his discretion. So therefore, the altered article after the debates gives no room except so far as the matters which are enumerated in the Constitution, where he can act without the advice of the Council of Ministers. One drastic article is Article 356 regarding proclamation of emergency. He can report to the President about the grave situation in the state. But then S.R. Bommay's case has said that when President acts on that, that is also justiciable. S.R. Bommay's ministry in 1994 was dismissed by the then Congress government, which was ruling throughout the country. S.R. Bommay went up to the Supreme Court and you can read the 9-judge bench decision. It is a wrong thing. When you exercise your discretion, it does not vary with the foot of the Chancellor. It has to have certain norms, certain constitutional propriety, and that I am not reading those that entire decision. Now in Shamsher Singh's case, in his inimitable style, Krishnayer said, V.R. Krishnayer, who had written a judgment, said that it is not the Potomac, but if you look at the river in imagery, it is not the Potomac, but the Thames, which fertilizes the flow of Ganges. So he was alluding to Westminster system, and he said, it is a Westminster system which we are following, where over the years, inexorably, the power of the king came down, and he could only act in advice of his council of ministers. Now there are several such provisions in the Constitution where governor has little role. But as our opposition leader put it, suppose he is ex officio or his duties are eo nomine as the governor, then he has a discretion. He is exercising not on the aid and advice, because that power is not conferred on him by the Constitution. That power is conferred on him by the statute. There he has got obviously the statute has to be amended if the state government so feels. Then if an ordinance is promulgated, he has to sign it, except where he finds under Article 213 there is some provision which is repugnant to one provision of the, if it is in the concurrent list, if there is a repugnancy, he has to get the prior instruction of the governor in the matter of ordinance. Insofar as a bill of the state legislature is concerned, he has to send it for the assent of the President. Now this small area, he has got a discretion. These controversies are not because the governors are exercising their power and sending bills to the Parliament. Even now, I tell you, there is one bill pending with the Union government for assent. It was passed when Mr. Ummanchandi was the Chief Minister. Malayalam language bill. I had drafted that. And then it was with much fanfare. In the closing days of that ministry, it was passed. Then it went to the governor. I had pointed out in my note that, look here, there is something called Official Languages Act. You cannot do this. If there is a conflict with Official Languages Act, then necessarily it will have to go to the president for assent. Then the special secretary, somehow, when I was one day leave, he signed it and sent to the governor. That day, governor was Chief Justice Sadashivam. He is not a person who would miss things. He has got exquisite knowledge of the provisions of the constitution. He sent back the bill. He said that I will not sign the bill unless I see the law secretary's note. So law secretary is expected under the rules of business to state that there is no repugnancy or any conflict with any law, either under the first schedule of the constitution or under the third schedule. Then I had to write that there is this trilingual formula which is accepted by the union government. I had to write that. And it is still pending with the Union of India. They have not given assent. So far they have not given assent. Now, but that was done in a very statesman-like manner. Now, if a bill is passed, governor does not like it, he squats on the bill and then issues press statements. It is not the problem with this constitution. It is a problem with the man who is manning the institution. I would say, with all, now that I am a lawyer, I have got the freedom to speak on all matters. But even, I am not speaking of individuals, but I am only saying that you cannot find fault with the constitution every now and then. It is basically the people who man the institution, they have to act in a statesman-like manner, because post of the president or the governor or the chief minister are constitutional, chief justice are constitutional posts. You cannot act like Justice Karnan. You cannot. Then you cannot blame the constitution for his actions. And I, for one, I say that if you can't rip apart the constitution, you have to deliberate on this. The Constituent Assembly, whom we call our founding fathers, they had brought out something like a miracle so far as our constitution is concerned. Obviously, it does have flaws. It has been amended over the years. Whether the amendments are good or not, only time can tell. As Oliver Wendell Holmes has put, only time can tell whether this is good or not. You cannot, at this point of time, pass judgments. I don't want to digress into other political matters like the UGCs and the pending sub judice matters, or the conduct of the governors all over India, or any other things. See, we have to, if you look at our history, I just wanted to digress a little. In the Mahabharata, in the Shanti Parva, you all know Shanti Parva. Yudhishthira, after the war, goes to Bhishma Pitama to study about the statecraft. He says, you shall not invest power in a person as a minister if he does not enjoy the popular will of the people. This is the same thing in Kautilya's Arthashastra. This is the same thing which has been repeated in various debates. You find the Hansard or whatever, wherever you look at our constitution, you look at our Supreme Court judgments. It is all Wavell, when he was discussing about granting India freedom just before the Indian Independence Act. He said, whatever constitution you make, if the people manning it are not good enough, it is a lost document. Thank you for giving me this opportunity. Thank you.
Thank you very much, Mr. Harindranath. We will, it's late and we must close, but if anyone has any burning question, you may please indicate and you will have a chance to express that. If not, we will conclude. I don't see anyone raising their hands. So then I take it that we will conclude. It's a working day tomorrow. I think we've had a very comprehensive discussion looking at this issue from various angles, lot of information. I think there's probably one aspect which we did not touch upon, which I'll just mention so that the audience can think about it. and that is a relationship between the governor and the president. And there is a Supreme Court judgment, Hargovind Pant versus Raghukul Tilak, AIR 1979, SC 1109, which said, I am quoting, the governor is an independent constitutional office which is not subject to the control of the government of India. This aspect we have not examined. I think the core problem is that there is a theory that the governor is the agent of the union government and must do the bidding of the union government. And governors are being chosen both by the current dispensation and by the earlier, the only other group that has ruled the country is our own Congress party. Both parties keep governors who are acting as agents of the union. But the Supreme Court reminded us in 1979 that the constitutional scheme is that the governor is actually an independent office. The president can remove the governor at any point of time because the governor is at the pleasure, holds office at the pleasure of the president. But while he occupies or she occupies that office, the governor should be an independent person whose only responsibility should be to uphold the basic structure of the constitution and the rule of law. The courts have said that repeatedly. But and so heard Dr. Thomas Isaac and Mr. V.D. Satishan express earnest political view that the governor should honor the constitution. All governors, not just this governor, all governors should implement the constitution in letter and spirit and obey it in accordance with their oath. Because much of the relationship between governor and chief minister and governor and the president and the central government is actually governed more by convention, committee and mutual courtesy, as Dr. Thomas Isaac pointed out, than by the law written into the constitution. Probably they did not feel it necessary to write into the constitution what was well accepted at that point of time. So the view from both of the political leaders is that, if I understand you correctly, that we should implement in letter and spirit, honoring democracy or parliamentary democracy and federalism. The office should be carried out in that manner. I think Mr. Harindranath has pointed out that there is a very solid body of jurisprudence that explains and supports the role of the governor as a democratic role, supporting the constitutional values. I remain a skeptic. I am not confident that this is the old situation. I think what is going on now is extremely a new game, and we are fighting for the survival of our constitution. And the office of the governor has become a major risk for the survival of the constitution and the republic. Dr. Thomas Isaac tells me that some of the left parties have actually asked for the abolition of the office of the governor. I think that's a good demand to make, or at least to go back to having the governors who are elected by the people, so that they are have a greater stake in democracy. So I'm skeptical that we can solve this problem by appealing to the good conscience of the union and the governor, because this is not by accident. It is a political aim that they are fulfilling. But we've had a full spectrum of choice. I want, on behalf of the panel, to convey our deepest gratitude and appreciation to the organizers, the Constitution Debate Club, and the the Kerala High Court Advocates Association for organizing a wonderful event. They put a lot of work into it. I want to particularly thank Advocate Parvati ma'am and Advocate Jacob for their extensive work over several days. A lot of detailed thinking and planning and action has gone into this program, and we want to express our appreciation to all the organizers for giving us this great opportunity. I want to thank personally, on behalf of the panel, this wonderful audience that has been very patient and has been with us for a couple of hours. I hope you found something to take away from here at least a message that we are facing a huge challenge and a huge crisis, not in terms of particular governors and particular conflicts, but in terms of the existential threat to our republic and our constitution. Let's all resolve to work together to uphold the constitution. Thank you very much again.
Thank you, dignitaries, for throwing light on this very relevant topic. I'm sure that this session would have enlightened each one of us, and now it is on us to ponder on the issue, on the information that is passed on to us. Thank you, dignitaries, once again. Now I request Additional Advocate General Ashok M. Cherian sir and Jayachandran sir to kindly felicitate our dignitaries with a memento. I request Ashok M. Cherian sir to hand over memento to Mohan Gopal sir, our moderator for the day. I request you, sir, to kindly hand over a memento to V.D. Sadishan sir. I request Jayachandran sir to kindly hand over the memento to Thomas Isaac sir. I request you, sir, to kindly hand over a memento to B.G. Harindranath sir. Thank you, sir. Thank you, dignitaries. Now I request Advocate Enoch David, EC member, CDC, to propose the vote of thanks.
Respected members on the dais, senior advocates, additional advocates generals, friends from the bar, students, ladies and gentlemen. We have had a very enlightening and deliberative session which took us through the constitutional post of our governor and his role as envisaged under the Constitution of India. As we conclude today's colloquium, it is my privilege to deliver the vote of thanks to our eminent speakers on behalf of the Kerala High Court Advocates Association and the Constitution Debate Club. To begin with, I would like to extend our deepest gratitude to Professor Dr. G. Mohan Gopal for having agreed to be with us today and to moderate the colloquium. We, the members of the Advocates Association and the Constitution Debate Club, could not have expected a more eminent person to moderate a colloquium of this nature. Sir, thank you so much. Our speakers for today were also of equal eminence. We have had the privilege of having amongst us Advocate V.D. Sadishan, the firebrand leader of opposition of the present Kerala Legislative Assembly. Even though we have seen him on several occasions on the virtual media, it was quite a different experience to see his academic and intellectual side on a constitutional issue of this nature. Thank you, sir, for having found time in your busy schedule to be amongst us. We are also deeply indebted to Dr. Thomas Isaac, our former Minister of Finance, for setting apart his valuable time to be amongst us and to give us a glimpse of his take on the constitutional issue that was discussed today. On behalf of the Advocates Association and the Constitution Debate Club, I would like to express our deepest gratitude to you, sir. It was also indeed our pleasure and honor to have with us Advocate B.G. Harindranath, a former Law Secretary to the Government of Kerala and a former District and Sessions Judge. His experience is multifarious in having been a professor at the National Judicial Academy as well as the Law Secretary to the Government, apart from having been a judicial officer for almost 3 decades. His views on the role of a governor from a constitutional perspective was indeed educative and thought-provoking. Sir, thank you so much for agreeing to be with us today. Thanks are definitely due to the President, Advocate Rajesh Vijayan, and the Secretary, Advocate K. Anand, and all other members of the Executive Committee of the Kerala High Court Advocates Association for their immeasurable support for this colloquium. Thank you everyone for your support. The President Advocate Parvati Sanjay and Secretary Dr. Tushara James of the Constitution Debate Club require a special mention as today's colloquium is undoubtedly their brainchild. On behalf of the Constitutional Debate Club, thank you so much for guiding and leading us in the most admirable manner. The Additional Advocates General, Sri Ashokam Cherian and Sri K.P. Jayachandran, have also taken time to be with us today amongst their busy schedule. Thank you so much, sir, for being with us today. Finally, ladies and gentlemen, thank you so much for your time. Thank you.
Thank you, sir. I once again thank all the dignitaries, and I'm sure that this session was indeed an enlightening one, and looking forward to more of such sessions by the Constitution Debate Club and Kerala High Court Advocates Association. Thank you all. I request everyone to rise for the national anthem.